Hello and welcome to 60 Seconds with Sergio. I'm your host, Sergio Cabanas, attorney at law here in Florida. Thank you so much for joining me today. So today's question is, Sergio, I've already been through this divorce, this paternity action, or some other legal event, and I don't like how certain things turned out, or I've changed my mind about certain things, and I'd like to go back and change it, to kind of make it better and refine things, to be more to my advantage. Is there anything I can do? The short answer is yes, under certain circumstances. Well, the easiest, most cost-effective way of correcting any situation like that is by simply reaching an agreement with your ex-spouse or ex-partner, getting everything documented in writing. It's very important. Oftentimes people come to me, they say, oh, verbally we discussed this, or verbally we had agreed to that. We've even done XYZ, and they're seeking now to enforce it. If it's not in writing, it didn't happen. So it's important to get these agreements in writing. And this document, whatever the agreement is that changes one of the terms of the divorce or the paternity case, has to be filed with the court and properly adopted by a new final judgment or an amended final judgment. That's what makes it legal and enforceable. If we're not able to reach an agreement, of course, it becomes a little more complicated. We have to look more specifically to the issue that we need to address. For example, if a given issue has not been made part of the case, for example, who's entitled to a child tax exemption, then the case can be reopened and the issue could be discussed or litigated. Depending on the circumstances, we could also go a different route. For example, if we can prove something unusual happened in the underlying case, such as fraud or some type of mistake, sometimes in a calculation of, for example, child support or alimony or equitable distribution, then that could be grounds to set aside whatever judgment there was and try to obtain a new judgment. Another example is the discovery of new evidence, and so forth. All of this should be reviewed and analyzed by your attorney to decide whether or not you can proceed under this route and be able to obtain a new judgment. Just keep in mind that if your case falls in one of these circumstances, the motion has to be filed within 1 year from the entry of the final judgment that you're seeking to change. And finally, of course, we have what's called modifications. That is, if there's a substantial, unforeseen change of circumstances since the entry of that final judgment, that might provide you with a basis to go back to court and change a certain aspect of the judgment so that we can reflect the reality of the situation. For example, if a spouse who is obligated to pay child support suddenly becomes permanently disabled, then that could be a set of circumstances that would warrant a modification of that final judgment. So if you find yourself in one of these circumstances, please don't hesitate to contact an attorney to get the right guidance. I hope this short video provided you with that extra guidance that you may need over a complicated area of the law. Thank you again for joining me today. And as always, stay informed so you can stay strong.